you need to keep in mind what are the national policies for that particular field of environmental law, because today Environment Protection Act is still a very widely worded notification or legislation, and a lot of power has been given to the executive body to come up with all sorts of notifications and GRs and circulars whenever they would like to. I can give you one small example: how to carry out aquaculture activity inside a water body. Now, there is no enactment when it comes to that as far as Maharashtra goes. It's an absolutely unregulated activity. Now, tomorrow, a particular circular can come up and say, can come up from the executive body, from the government department that says, okay, we are going to regulate aquaculture activity by X, Y, and Z measure. It could come up with that. But at the same time, since you do not generally tend to have, or you will find loopholes or gray areas where there are no such notifications, no such circulars that clearly regulate something of this particular issue that you're coming up, there is no regulation per se, then you need to start looking at whether there are any national guidelines, whether there are any national non-binding research framework document that has, which is called RFD, any research framework document that has been set up. Because even with each ministry, there are certain different kinds of departments. For example, Ministry of Environment has different departments under wildlife. It has departments of inland water body, coastal body. So they have different departments. Each department, sometimes when there are good IAS officers and there are good bureaucrats sitting there, also end up having documentation of particular guidelines that how things should function. They're completely non-binding in nature, but if you get your hands on these guidelines of that particular issue that you're dealing with, attach it. You need to use it in your cases.